there, and he was doing what he had to do to protect himself. So yes, it's going to be graphic and difficult for the jury to watch, but the defense is going to try to make it seem like there was no option here and that the defendants themselves were in danger and that Ahmaud Arberey was attacking them. And so it's going to be a difficult argument, I think.
13 over a little bit. Perfect. Thank you.
So you can hear the judge, Terry, actually moving the jury. There are strict COVID restrictions going on inside this courtroom. So he's already asking jury 13 to move over a little bit.
I should say,
here we go. Let's listen in.
As I indicated to you the other day, we're going to get started with opening arguments and hopefully get into some evidence in this case. Before we do so, I'm going to go ahead and swear you in as the panel in this case, and then I'm going to give you some preliminary instructions. Once I have finished with that, we're going to move right into opening statements. So if I could please have you stand and raise your right hand. Ladies and gentlemen, you shall well and truly try the issues formed upon this bill of indictment between the state of Georgia versus Travis McMichael, Greg McMichael, and William R. Bryan, who are charged each individually and as parties concerned in the commission of a crime by the grand jury of Glynn County in an indictment with the following charges: count 1, murder; count 2, felony murder; count 3, felony murder; count 4, felony murder; count 5, felony murder; count 6, aggravated assault; count 7, aggravated assault; count 8, false imprisonment; and count 9, criminal attempt to commit a felony. And a true verdict you shall give according to the evidence, so help you God. All right, thank you, ladies and gentlemen. Please have a seat. All right, first off, can everybody hear me? All right. Ladies and gentlemen, you have been sworn and impaneled, and you're about to try a criminal case entitled the State of Georgia versus Travis McMichael, Greg McMichael, and William R. Bryan. The defendants have been charged each individually and as parties concerned in the commission of a crime by the grand jury of Glynn County in an indictment composed of the counts that I just read to you in the oath. To this indictment, the defendants have pled not guilty, and each denies every allegation therein. This is what forms the issue that you have been selected, sworn, and impaneled to try. Before we begin the trial, I'm going to give you some preliminary instructions on fundamental principles of criminal law. I will also instruct you on the role of the judge, the jury, and the lawyers, and give you an overview of the trial procedure. Many of you may have never served on a jury before. It is therefore necessary that these instructions be given so that you have a general understanding of the procedure in a criminal trial, what will be expected of you, and how you are to conduct yourself during the trial. The defendants are charged in the indictment with crimes that are violations of certain laws of the state of Georgia. I want to emphasize to you that the indictment, including all of the counts therein, and the pleas of not guilty are the legal procedures by which these criminal charges are brought against each defendant. The charges and the plea of not guilty are not evidence of guilt, and you should not consider them as evidence or implication of guilt of any crime whatsoever. The defendants are presumed innocent until each is proven guilty. Each defendant enters upon the trial of the case with a presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime or crimes charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. However, The state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. There's no burden of proof upon the defendants whatsoever, and the burden never shifts to a defendant to prove his innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. Though you may consider all of the evidence as a whole, conviction of one defendant does not necessarily require conviction of another. You, the jury, must determine whether the state has proven the guilt of each defendant beyond a reasonable doubt. If, after giving consideration to all of the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should acquit that defendant. But if no doubt exists in your minds about the guilt of the accused, then you would be authorized to convict that defendant. If the state fails to prove a defendant's guilt beyond a reasonable doubt, it would be your duty to acquit. Now, under our system, it is my duty as the trial judge to determine the law that applies in this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at a verdict. I'm giving you some of those instructions now. I will give you more detailed instructions after the evidence has been presented and the lawyers have made their closing arguments. During the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making these rulings or at any time during the trial is evidence, and it should not be considered as an indication that I have any leaning in this case whatsoever. My only interest in this case is to see that it is fairly tried, according to the laws and the Constitution of the state of Georgia and the Constitution of the United States. As expected, the lawyers serve as advocates to their clients and are duty-bound to represent their clients to the best of their ability. The lawyers also serve as officers of this court, and as such, they are bound to follow applicable laws, trial procedure, and rules of evidence during the trial. If at any time the lawyers believe that any law, procedure, or rule of evidence is being violated, they may make motions regarding the conduct of the trial or objections to the admission of evidence. In making these motions or objections, the lawyers are simply seeking to fulfill their duties to their clients and to the court. Now, sometimes these motions or objections may require the court to consider issues outside your presence. When this occurs, you will be excused to the jury room. We will try to minimize the number and length of these interruptions, and I do ask for your patience when this occurs. Now, ladies and gentlemen, trial procedure in a criminal trial is generally as follows. First, the attorneys for both sides have the opportunity to make what is called an opening statement. This opening statement is not evidence. Remember that what the lawyers say is not evidence, but it is a preview or an outline of what they expect the evidence to be. Following the opening statements, evidence will be presented. Evidence can be in the form of testimony given by witnesses or physical evidence that will be labeled with exhibit numbers for identification. After the presentation of evidence, the attorneys have the opportunity to make what is called a closing argument. At this time, the attorneys may suggest which laws are applicable and how they should be considered in light of the evidence. Following closing arguments, I will charge you more specifically on the law that applies to this case. I will then ask you to retire to the jury room to deliberate and to reach a verdict. Now, the jury has a very important role. You must decide the facts of the case from the evidence presented, and then apply the law I give you to those facts. Now, evidence is the means by which a fact is established or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from people who take the witness stand and swear to tell the truth. Exhibits are documents, photographs, and other physical items that are admitted during the trial. Certain things are not evidence and must not be considered. For example, statements and arguments made by the lawyers are not evidence. In their opening statements and closing arguments, the lawyers will discuss the case and provide an overview. But again, their remarks are not evidence. Also, questions and objections made by the lawyers are not evidence. Only the witness's answers to questions are evidence. Now, I will admit or exclude evidence according to the rules. If a lawyer makes an objection and I overrule it, that means the evidence is admitted and you may consider it. On the other hand, if I sustain an objection, this means that the evidence is excluded from the trial and you may not consider it. You should consider only that testimony and only those exhibits that are admitted. You should not assume or infer anything about evidence which I have excluded. If you happen to hear or see evidence that I end up excluding from the trial, you should disregard it entirely in your deliberations and in arriving at your verdict. Now, ladies and gentlemen, you, the jury, must determine the credibility and believability of witnesses. It is for you to determine which witness or witnesses you will believe and which witness or witnesses you will not believe, if there are some whom you do not believe. In determining the credibility or believability of witnesses, you may consider all of the facts and circumstances of the case, the manner in which the witnesses testify, their interest or lack of interest in the case, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, and the occurrences about which they testify. You may also consider their personal credibility insofar as it may appear to you from the trial of the case. As the fact finder, it is your duty to believe the witnesses whom you think are most believable. It is for you alone to determine what testimony you will believe and what testimony you will not believe. Now, it is important that you pay close attention during this trial. If at any time you cannot hear or see the evidence, or if you are suffering from any discomfort that distracts you, please inform me or the bailiff, and we will do what is needed to make sure that you can hear and see the evidence and give it your undivided attention. If you need a break at any time, please raise your hand or alert one of the bailiffs, and I will recognize you. Now, you should consider the evidence with an open mind, and you should not reach any final conclusions until the trial is over. Do not jump to conclusions before all of the evidence has been presented. Remember that you are the ones who have been qualified as fair and impartial jurors deciding this case. No other influence should affect your decision. For that reason, you may not discuss this case with anyone, including family and friends, or let anyone discuss the case with you or around you. This includes discussing or sharing information by email, texting, blogging, or any form of social media until actual deliberations begin. That is, until after you have heard all of the evidence, the lawyer's closing arguments, and you have been fully charged on the law that applies to this case. You must not discuss this case even amongst yourselves in the jury room, during breaks, or anywhere else. Do not at any time during the trial request, accept, agree to accept, or discuss with any person any type of payment or benefit in return for supplying any information about the trial. You must promptly tell me about any incident you know of involving an attempt by any person to improperly contact or influence you or any other member of the jury. Now, I've asked the deputy, or the bailiff in this particular case, to provide you, I guess deputy, I got both words. So I've asked the deputy to provide you with pencils and notepads for your use during trial. You may take notes, but you are not required to do so. If you decide to take notes, please remember that note-taking should not divert you from paying full attention to the evidence and evaluating witnesses' credibility. Your observations of the witnesses during their testimony can be vital to your determination of the believability of their testimony. The notes that you take are for your use only, and they're not to be shared with anyone. Lost my notes here. Not to be shared until you begin actual deliberations with your fellow jurors. Sorry about that. Now, notes are not evidence, only memory aids, and they should not take precedence over your recollection. It is the duty of each juror to recall the evidence, and while you may consider another juror's notes to refresh your memory, you should rely on your own recollection of the proceedings. Do not be influenced by the notes of other jurors unless their notes help you in determining your independent recollection.